Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is BINTI Muhammad Sabirin and welcome to my channel. Hi, so I introduce again myself. My name is BINTI Muhammad Sabirin and I'm 22 years old. I'm from Negeri Sembilan and currently pursuing LLB in UNIZA. So generally this is my first ever vlog in my channel, because before this I just posted my assignment videos and never talk about myself or talk in front of camera like this. And basically this is a task given by my lecturers, Prof ZUHAIRAH and Madam FARHANIN, which I need to talk about myself and giving some legal advice. So let's go through the first task, which is I need to talk about myself. So basically I born in Negeri Sembilan and entering high school in Sekolah Menengah Agama Persekutuan Labu, also in Negeri Sembilan, and I pursue in Diploma in Law in UNIZA. I managed to finish my Diploma in Law despite the tears and everything, and again I make a choice to pursue LLB. Basically the thing that inspired me the most to pursue in LLB is my parents. But I still remember the day after I having my graduation for Diploma in Law in UNIZA. During that day, my mom said to me she's proud of me, and my dad said that one day he wanted me to be a lawyer. He wanted to see me become a lawyer, and I was like, I don't want to make them upset with me. One day I'll make it true. I'll show it to them. That is the main inspiration for me why I still pursue law. So yeah, that's the end of the first task. So let's go to the second task. So welcome back to my second task, and here is your advocate and solicitors, BINTI Muhammad Sabirin. As we know now, we are in movement control order, and there are a lot of legal issues arises regarding their contract, whether the movement control order can cause breach of contract. Generally, I would say that it may cause to breach of contract, and the contract also can be protected. How you can protect your contract? The first one is you need to check in the contract whether there's a force majeure clause. So what is a force majeure clause? Force majeure clause is a clause that specifically mentions certain situation. For example, you need to check whether in your contract there is a clause that said or mention pandemic, epidemic, disease, or there's a catchphrase that mention beyond the reasonable control of the parties. Second, you need to check in your contract whether there is any specific timelines, notifications, or procedures to suspend your contractual obligations. The third thing is you need to check whether in your contract there is any termination clause in order to determine if it's allowed the termination by no fault termination or by the termination due to the force majeure clause. Don't worry if there's no force majeure clause in your contract. The contract still can be discharged by the way of frustration, and the contract will become void. A contract is said to be frustrated when there is a supervening event that interfere with the contract, which later render the contract to be radically different as what had been agreed before. So how to discharge a contract under frustration? In order to discharge the contract under frustration, there are few elements that need to be fulfilled. The first one is it must be proven that the event or the change in circumstances upon which a party claims to have frustrated the contract must not have been one for which provisions have been made in the contract. The second element that need to be fulfilled is The event or change in circumstances must be one for which the party is not responsible for or not self-induced. Lastly, the event had rendered the contract radically different from what had been agreed to the extent that the court must find it is unjust to enforce the original promise. So if you fail to prove all the elements of frustrations, the contract can be declared as void and there is a breach of contract. However, there is another alternative to protect a contract where recently the government had passed the temporary measure for reducing the impact of coronavirus disease 2019 COVID-19 bill, where this bill regulates temporary measures to reduce the impact of the COVID-19 pandemic. Such measures are meant to address the effects of the pandemic on the country's economy and well-being. In this COVID-19 bills, on the part 2 of the bill concerning on the contractual obligations and claims, apart from that, Clause 7 of the same bill specified that if a party is unable to perform their contractual obligations due to any of the measures undertaken pursuant to the Prevention and Control of Infectious Disease Act 1988 to stop the spread of COVID-19, the innocent party will not be entitled to exercise their rights under the contract. However, on the part 2 of this bill, protect and concern regarding the contractual obligations and claims, the categories of contract that we protect under this part 2 of the bills is, the first one is the contract regarding construction or supply of construction material, equipment or workers. The second one is performance bond granted pursuant to a construction contract, professional services contract, lease or tenancy of non-residential property, event contracts, contract by a tourism enterprise, and lastly, the contract regarding religious pilgrimage related contract. However, regarding the Clause 7 of the bill, in order to rely on the Clause 7, the parties must prove that they cannot perform the contractual obligations because of the measures that had been taken to stop the spread of the COVID-19. However, the bill is silent on the requirement on the part of the default party before seeking the relief under the bill. Apart from that, Clause 9 of the bill provides the option of settling any dispute under the Clause 7 through mediation. If the mediation process is successful, Clause 9, Clause 3 of the bill state that parties must then enter into a written settlement agreement duly signed by both parties and will thereafter be authenticated by the mediator. The bill further stated that the duly authenticated settlement agreement shall be binding on both parties. Therefore, if the contract cannot be protected by any category that had been mentioned before, the contract can be declared as breach of contract and the contract will be declared as void.